This is Dish and Dirt with Gary Pickren, South Carolina's only podcast dedicated to the real estate agent craft. And now, the host of Dish and Dirt, Gary Pickren.
And greetings and welcome back, everyone, to another episode of Dish and Dirt. I'm your often opinionated, rarely wrong host, Gary Pickren, coming to you from the beautiful downtown Columbia, South Carolina offices of Blair, Cato, Pickren, Castelline. This, the first week of August 2025. This is also, by the way, episode number 233. Dish and Dirt is coming up on its 5th anniversary in September. That is right. 5 years ago in September, we started Dish and Dirt. It was originally going to be once a month, and I was going to do maybe 15, 20 minutes once a month, and it quickly turned into once a week, and we are now heading toward our 5th anniversary and 150 episodes. It's hard to believe, but we really appreciate everybody's support and everybody who listens, and particularly everybody who comes up to me and tells me how much they're enjoying and they're getting a lot out of Dish and Dirt and how it's helping you and your career. So thank you so much for y'all's support, and be on the lookout for a lot of fun things coming up as we hit the 5th anniversary of Dish and Dirt. So today on Dish and Dirt, what we're going to do is we're going to discuss the case that I mentioned last week. If you listened last week to Dish and Dirt, we talked about builders and what the builders can't do and what they can do, builder agents and so forth, according to the Real Estate Commission. And during that discussion, we talked about Dawkins versus Eastwood Homes of Columbia, South Carolina. And this case here involved several builder provisions in their contract that the court deemed substantially unconscionable. So what I want to do today is dig a little deeper into that, because these provisions aren't unique to Eastwood Homes. In fact, these provisions are in most, if not all, of the builder contracts. And so what we talk about here today and what the court talked about in Dawkins versus Eastwood Home is in fact very relevant to not only you as an agent, but also to your buyer client. So we need to look deeper into this case to see what this case is talking about. And we're going to do that here in just a minute. But first, we do have some very fun news for Dish and Dirt fans. The South Carolina Realtors Association has asked me, Dish and Dirt, Gary Pickren, to do my podcast live because, of course, the podcast is the #1 real estate podcast in South Carolina. But they want me to do this podcast live at the South Carolina Realtors Legal Conference called Realtor Mania. So I will be live on stage doing a live episode of Dish and Dirt. I already have, I believe, a fantastic guest lined up that is going to bring so much great information. You do not want to miss this episode. Now, this conference is going to be held at Wild Dunes, September 17th through September 18th. If you haven't already registered, and I know a lot of you already have, but if you have not already registered, you can register now at screaltors.org/realtormania. Few tickets are left. You need to go ahead and get your tickets now. Do not wait. I'm sure this is going to sell out. Nick told me a lot of tickets are already gone, so there's not a lot of tickets left. So you need to go ahead and get your tickets now so that you don't miss this, because you don't want to miss an episode of Dish and Dirt live on stage. Now, at Realtor Mania, there's a lot of good stuff going on, great education opportunities. You're listening to Dish and Dirt because you want more education opportunities. You're a top real estate agent. The way to be a top real estate agent and to remain a top real estate agent is to get the education that you need, whether it's training on forms or legal matters, the real estate commission matters, and so forth. What we know is at Realtor Mania, we're going to have form training, broker and agent training, a real estate commission update. I'll be part of that panel. We're going to have a legal update. There's a lot of great legal minds who are going to be on a panel talking about what's going on in the legal world of real estate. And believe me, since Sitzer Burnett, the legal world of real estate changes almost daily, it seems. We're going to have an economic update. We got networking to talk about, because you're going to have a lot of networking opportunities with agents from other parts of South Carolina who might be able to refer a friend or a client to you. So a lot of good reasons to be there. And as we know, post Sitzer Burnett, as we're hitting the 1-year anniversary, we're heading right toward it. It's going to be here August 17th, just a few weeks away, 2 weeks away. We've got Sitzer Burnett still on our minds, and we got to talk about that. But as we continue to look at what Sitzer Burnett has done to the real estate industry on a legal aspect, it's very important that you attend these legal conferences to figure out and to understand what's going on and how to adapt your business. I've already talked to a couple of the two biggest agents I work with in South Carolina, and both of them have told me that these legal changes are in fact making their business better. They're excelling. They are winning. They're making more money than ever. Understanding what you legally and legally can't do, and understanding how to use that for yourself to make your representation of your clients better does have an economic impact on your pocketbooks. You absolutely want to be there. Plus, I'm going to be broadcasting live. So if that's not enough, I'll also be on the Real Estate Commission panel that day 2 times that I'll get to tell you my often opinionated but rarely wrong views. Also, before we move on to our show, the 20th of August is our Sumter grand opening. You know, we've been open in Sumter already for several weeks now, doing closings 5 days a week there in office. We are having our grand opening, though, at Hardy Cove on August 20th. So if you're in the real estate industry, we hope that you will come out on August 20th to our grand opening. I believe that begins at 4 o'clock. And so you need to come out, put that on your calendar, look for more information on our social media, as well as here on Dish and Dirt. And then finally, on August 21st in Greenville, we are having our grand opening at the Commons. If you haven't been to the Commons, use this as your opportunity to go to Unity Park and the Commons. They did an incredible job rehabilitating this old warehouse and making it some of the most beautiful office space in all of Greenville. And y'all know Greenville's full of beautiful office spaces, but you'll absolutely love to see what they've done in Greenville, as well as to meet our incredible Greenville team led by Adam Bro. And we are real excited to be in there. So y'all join us on the 20th in Greenville. Now, let's dig deeper into this builder case. Before I do, I want to give you my crystal clear statement again. I did this last week. Do not take this podcast as being anti-builder or anti-builder agents. You know, Blair Cato has made its 10-year history and has grown to the biggest real estate law firm in the state by working with helping real estate agents, whether they're builder agents or non-builder agents, whether they're builders or not builders. We love all parties involved in real estate. We love helping real estate agents, whether you represent a builder or not. We love helping our builders as well. The purpose of Dish and Dirt is to bring everybody together, to educate everybody, to let everybody know what's going on. And I have to tell you when it's good, when it's bad, and when it's ugly. And sometimes, unfortunately, as we've been able to live through the last year of Sister Burnett, real estate ain't always pretty. It's not always good. And so sometimes we have to talk about the bad side. And today's one of those ways we're going to talk about, our days we have to talk about some of the things that maybe not everybody likes. So this is going to be talking about a builder case, but this is not anti-builder, certainly not anti-builder of anybody I mentioned here today. This case did come before the Court of Appeals, which is the second level of court. You have the Circuit Court, then the Court of Appeals, then the Supreme Court. The case was tried and then brought to the Court of Appeals to determine if it was tried correctly. Now, this opinion we're going to talk about today is an unpublished opinion, but what that means essentially is it doesn't have precedential power, but it does have persuasive power. And it is something we need to look at to determine why the court is making this determination and how should we change how we are acting in the future so that we don't have a case against us. I think the reason it is unpublished is perhaps maybe it didn't put any new law into the universe, or perhaps it's very fact specific. Nevertheless, this case should have persuasive power on how we operate with builders moving forward. What this case involves is a contract dispute between a residential home buyer named Eastwood and several home buyers. The sole issue that came before the court was whether certain provisions in Eastwood's standard contract were unconscionable or were they against public policy. Now, the case came from a contract between Eastwood and 9 individual home buyers, and these were buying homes. These home buyers were building semi-custom homes in a neighborhood that was an Eastwood neighborhood on Johns Island in Charleston County. Each of these 9 home buyers had separately signed the standard Eastwood contract agreement for the construction of these houses. The very short version of this case is that Eastwood, under the terms of the contract, terminated the contracts with the respondent before the sales closed. They refused to sell the house to them. They terminated the contract, returned the earnest money and $100 in damage. Eastwood claimed to the court that it had the sole authority and discretion to terminate the contracts pursuant to 2 provisions in the contract. Specifically, they pointed to paragraph 25 and paragraph 26. The court reviewed these in reverse, so we'll do the same here. In paragraph 26, it was titled Seller Option to Cancel Prior to Closing. And what it stated in the contract was, if for any reason a bona fide dispute should arise between the buyer and Eastwood in Eastwood's sole judgment prior to closing, and if such bona fide dispute cannot be resolved to the mutual satisfaction, then Eastwood at its sole option may terminate this contract by written notice to the buyer prior to closing. Now, one of the first things the court did note was that this provision is somewhat ambiguous because it really doesn't talk about what is a bona fide dispute. What does it mean by it can't be resolved by mutual satisfaction? And if it's got to be resolved by mutual satisfaction, then how does Eastwood have the sole option then of terminating? Because then at any point they can just say there's no mutual satisfaction to terminate. Let's look at also what it said in paragraph 26. It says, If Eastwood terminates the contract, Eastwood must return all deposits to the buyer and pay an additional amount of $100 as liquidated damages in the event Eastwood's cancellation constitutes a default under the agreement. The paragraph precludes, otherwise prohibits, the buyer from pursuing any other remedy. So what this is saying is if Eastwood determines in its sole discretion that it wants to terminate the contract, and that determination somehow was wrong, that Eastwood defaulted in the contract by terminating, they didn't have the power to terminate and they just did, that all the buyer gets back is all of their earnest money or deposits and $100. And that's it. That's your liquidated damages. Doesn't matter what damages that you suffered, what problems you suffered as a result of Eastwood wrongfully terminating the contract. If that termination was wrongful, the sole thing you get is $100. The court then looks at paragraph 25, which is very similar, and it says that Eastwood, if you default, has an array of remedies, including all damages, any and all damages you can go after as Eastwood. However, if Eastwood defaults, the last sentence of the first clause of paragraph 25 only allows the buyer to recover deposits made, and it shields Eastwood from any liability for consequential damages or for damages or delay, and it constitutes essentially a release and waiver of any and all claims against Eastwood. So essentially what paragraph 25 says is if Eastwood defaults, we'll give you your money back. The money you paid us, which is your money, by the way. It's not Eastwood's, it's your money. So all we're going to do is give you your money back, but you can't come after us for anything at all. Not any of your damages, not any of your costs, not any of your out-of-pockets. You get nothing. But Eastwood, on the other hand, if you default, can sue you for everything under the sun. There is no limitation except what is limited by the law as to what they can sue you for. In this case, the court said that Eastwood sent each of the buyers a mutual release and that the releases explained that the contracts were being canceled. They also included the refund of all their deposit or earnest money, and they gave them that $100 for their damages. Now, the additional thing that Eastwood did here was they included an offer of first refusal on the homes when they were eventually constructed, but at the future current market price, not the price that these contracts were already under. So if they've already signed a contract for $500,000, and when the houses were finished, the houses were now selling at $600, then you could buy the house at $600, not at $500. The respondents didn't sign the mutual lease, needless to say, and they filed the lawsuit. The termination, the reason for the termination here, according to the court, was not really germane to this argument because the only question here was whether these provisions or not were unconscionable. So it really didn't matter what the reason was given. So they didn't even look at the reason. But you and I know why these contracts typically get canceled under these provisions. It's the price of the house has gone up substantially, or the builder can't deliver as promised because of delays, or thirdly, they just don't like dealing with this buyer anymore. This buyer's asking too many questions, making too many demands, wants to see too many things. And so that's typically why these contracts get terminated. I do find it interesting that in all these contracts, there's no provision that the buyer can simply cancel if the price of the house drops or the neighborhood becomes a fire sale neighborhood, such as the builder starts selling all the houses at reduced costs just to try to get rid of their inventory. It doesn't give the buyer the right to terminate the contract and pay the builder $100 as damages. The builder can actually sue for specific performance and damages and all of that. Now, let's look at how the court determined whether or not this contract was unconscionable. According to the court, unconscionability is a fact-specific inquiry that must be decided on a case-by-case basis. And the court says you have to look at all the pertinent facts and the circumstances, but that's limited to those existing at the time the contract was executed. We're not going to look at what happened during this case. We're going to look at when the contract was signed, what were those facts and circumstances at that point. And the analysis itself, according to the court, is actually divided into two prongs. There's a procedural unconscionability aspect of it. And what that means is it's best described as an absence of meaningful choice, and it typically speaks to the fundamental fairness of the bargaining process. And so let me stop there for a second. What is procedural unconscionability? Is this a take it or leave it type of transaction? Is there any meaningful choices that the buyer has other than take it or leave it? And is that fundamentally fair? Is that fair in this bargaining process, or is it just so one-sided that it's either take it or leave it? The second prong then they have to look at after you pass the first prong is it substantively unconscionable? What's the substance of this contract? Is that unconscionable? And it finds its footing in terms that are so one-sided, that are oppressive, that no reasonable person would make them and no fair and honest person would accept them. Then that would be substantively unconscionable. So in this process, we got to look at, is it unconscionable in its process, and is it unconscionably in its substance? Eastwood's argument was basically this. that these respondents were highly sophisticated, highly educated consumers because they're buying second homes on John's Island, very expensive houses. And that these very highly educated and sophisticated consumers, they signed these contracts with full knowledge of what they were signing and all the provisions. It's equal bargaining power. However, the court did find that this contract was what's called an adhesion contract. And Eastwood did not dispute that this contract was an adhesion contract. Even though these cases involved second home buyers, these buyers were very sophisticated and had a high education. What the court noted was the contract as an adhesion contract, that one party to an adhesion contract has virtually no voice in the formulation of the terms and language used in the contract. And the courts tend to view adhesive agreements with considerable skepticism, as it remains doubtful any true agreement ever existed. So what the court is saying is, okay, Eastwood, we're listening to you. Yes, they're highly educated and sophisticated, but in this case, it really doesn't matter because this is an adhesion contract. And in this adhesion contract, these buyers had no voice in the formulation of the terms, what was put in the terms, and really the contract's non-negotiable. So what the court's going to do here when they look at this procedural unconscionability is they look at the fact that the standard contract that Eastwood provided is given to all home buyers, not just these sophisticated or highly educated home buyers. And when they give these contracts to these home buyers, there's only a few blanks left to be filled in. Typically the buyer's name, the property address, and the price. And oftentimes the price isn't even negotiable. And all the other terms in the contract of the purchase and sale agreement of any consequence, any of these terms are basically non-negotiable, particularly when there are consequences that affect the seller developer, such as their rights under default or how they can be sued. All of that is non-negotiable. The court, in reviewing this and looking to determine procedural unconscionability, did look at a case called D'Amico versus Lennar, Carolinas. And what the Supreme Court of South Carolina said in that case was the sophistication of the individual home buyers, their education, their knowledge level, paled in comparison to the home builder general contractor, given that the builder had sold thousands of homes, whereas the buyer would likely only purchase at best a handful of homes in their entire lifetime. And they characterized the builder as significantly more sophisticated than the buyers in the home buyer transaction. I think pretty much the same in all builder contracts. You are dealing with highly sophisticated national builders in most cases that are building thousands and thousands of houses a year. And the home buyer typically buys 2 or 3, 4 or 5 houses in their entire lifetime. The plaintiffs in this case argued that, yes, we are intelligent and successful in our careers. I mean, would you expect them to say, no, we're stupid and didn't do well in our careers to be able to buy a $500,000 house? But what they said was that the D'Amico case suggests that their intelligence and success does not put them on an equal playing field with this very large home builder like Eastwood, and specifically in the context of a home buyer purchase when it's a take it or leave it non-negotiable form contract. And that's what they're saying this was. It basically was a take it or leave it non-negotiable contract. Furthermore, they said there was an element of surprise in how this paragraph was applied. We already talked about it. The language was somewhat ambiguous, and their belief was there would be a serious negotiation of the terms and some type of resolution, and it wouldn't result just any time that the buyer had a question or didn't like something that was just going to automatically result in the termination of the contract. So the court essentially finds at this point that this contract is procedurally unconscionable because there was not equal bargaining positioning, it was non-negotiable, and that the builder had an unequal power over these home buyers. Just take it or leave it, non-negotiable contract. So when the court then turns to look at it to see if it was substantively unconscionable, the court said, sure, it's true that adhesive contracts are not unconscionable in and of themselves, but the terms must be even-handed. And you can look at our contract, the SCR contract or the state contract. They're pretty much adhesive contracts. The contracts are already set. There's not much negotiable terms in the terms of the contract, though typically you could negotiate anything that's written in the contract. We recognize that in most cases that's not the case, but the terms are even-handed. So if you're going to have a contract that's essentially take it or leave it as a builder, then your terms have to be even-handed. And what the court is saying here is that's not the case. The builder here has a contract that's take it or leave it, non-negotiable, but the terms are so one-sided that it's unconscionable. It's so unreasonable as to render them unconscionable is actually what they said. The court said, quote, a contract may be considered substantively unconscionable when a clause or term in the contract is totally one-sided or overly harsh, such that it oppresses or unfairly surprises an innocent party, and that there is an overall imbalance in the obligations and rights imposed by the bargaining They actually cited a court case there. And then they said a term may also be said to be substantively suspect if viewed at the time the contract was formed. It reallocates the risk of the bargain in an objectively unconscionable and unexpected way. Eastwood again tries to rely on their argument again here that these were sophisticated, experienced, educated buyers, contends the provisions cannot be deemed unconscionable because they merely return the buyers to the position they were in before the contract. But here's what the court said about that argument. And I love this. We're not persuaded. That's all they said. We're not persuaded. Your argument is so irrelevant, we're not even going to argue about it. It's just not even persuasive. In interpreting the provision that Eastwood's offered at trial, the master, which is where this case was tried, the master in equity, the parties didn't dispute this, that paragraph 26 is actually a termination at will provision allowing Eastwood to cancel the contract for any reason and its absolute discretion. And the court says this is plainly one-sided, and at least it was an unexpected surprise and provided an imbalance of power by giving the home builder who's already in a superior position the unilateral power to cancel the contract. As to paragraph 25, the court said their concerns were more centered on the lack of mutuality of remedy, because if the respondents defaulted, Eastwood was in a position to bring any and all claims and seek any and all damages against the buyers. But if Eastwood defaulted, then all you can do is get your money back in $100. The court also handled this issue, saying it is true that parties are free to contract away all their rights and that this mutuality of remedy is not required by a contract. However, with paragraph 26 allowing for the unilateral no discussion cancellation and paragraph 25 allowing the only recourse to be return of the money in $100, Eastwood is effectively shielded from any liability with a full coat of armor, and they do not see how a reasonable person who would have agreed to terms with such lopsided effect in the home purchasing scenario. And if you think about that, that's true. Eastwood in this situation can terminate the contract for any reason and pay $100. So essentially, if Eastwood is going to default or doesn't want to do something, instead of defaulting, all they have to do is just give you $100 and they're out. And the court says that's not reasonable. In fact, the court actually cited Smith versus D.R. Horton, a similar case that happened several years ago where D.R. Horton had disclaimed implied warranty claims and prohibited any monetary damages, which the court said were clearly one-sided and oppressive. And what would happen if you had a defect in your home, D.R. Horton in its sole discretion got to determine whether they were going to repair or replacement, but you could get no money. And the court said this is no remedy at all because it leaves the relief to the whim of D.R. Horton while simultaneously allowing no monetary recuperation. So in conclusion, what the court says is we have fully considered Eastwood's point that up until closing, Eastwood bore a large portion of the cost and risk in building these houses, but even so, the provisions at issue under the master's unchallenged interpretation allows Eastwood to evade any liability, cancel its contracts for any or no reason at all, and provide buyers with no recourse if Eastwood were to default other than to refund their money and give them $100. This result that the defaulting consumer is fully exposed to the liability, but the defaulting builder is completely insulated, is completely asymmetry, and is at odds with the rule that the party may terminate a contract so long as the termination follows the contract and is not contrary to equity and good conscience. The court found this to be extremely procedurally and substantively unconscionable, these provisions. Now, Eastwood did get a victory here. The court did look briefly at the public policy issue and said they don't find this to be a public policy issue. It's more of a contractual issue as to whether it's unconscionable or not. So there is a small victory there. So now that brings us to the final part of this podcast. So what? I had a law professor in law school who would always ask that. You would brief a case and then he goes, so what? You told us what the case said, but what does it really mean? Well, I think what this means is this is yet another warning shot that's being fired over the bow of the builders, that these contracts are unconscionable, that these totally one-sided, non-negotiable contracts are not going to be upheld by the court. The court finds them unequal. They find unequal bargaining power, regardless how smart or educated the buyer is. It doesn't matter. These are unconscionable on their face, and these provisions are going to be thrown out. And these unilateral rights to terminate, the court has determined these are unconscionable, and especially when you couple those with unequal rights of default. So I think builders need to go back and look at their contracts and probably remove these rights to unilaterally terminate, particularly when you tie it into, we don't have to pay you for default, but you owe us the world when you default. Those are unequal remedies, and I think the court's going to say those are unconscionable based on the unconscionable bargaining power at the time of contract. Now, unfortunately, despite this very, very damning language in this case, I personally don't think you'll see any rush by any builder to remove any of these provisions from their contract, even though they're likely unenforceable. I think there'll be a hope that buyers just won't know better and will continue to push these. But if I was representing a builder, my position would be, you guys need to see the light here. These courts are clearly saying they don't like these cases, they don't like these provisions, and they're going to hold these provisions unconscionable. And so if your position as a builder going, yeah, I know that's probably going to be rendered unenforceable, but I'll wait till the court says that, I think it's missing the second point of the case, which is the tide's turning. And when courts are saying these things, that opens it up to somebody like Michael Ketchmark. Lawyers are not going to sit here and let a lawyer like Michael Ketchmark make $500 million and not think to themselves, where can I get my piece of this pie? And so when the courts are telling us that these builder contracts are unconscionable, and we've got two cases here, this case as well as the D.R. Horton case, that these provisions that limit recoveries from the buyers to basically nothing, but the builder can sue you for everything and they can terminate the contract for no reason, but you can't. And what you could see now is that somebody like a Michael Ketchmark compiling these cases and going after builders as a class action. And to think that this isn't possible, this isn't happening, is to ignore your enemy. Your enemy, Michael Ketchmark, has already told you he's looking at other things in this industry. He's already taken $418 million off the Realtors Association. He's not going to stop there. He's telling us he's not. He's looking at JVs. He's looking at these agreements that realtors have with builders, these agreements that realtors have with lenders and title companies where they're getting paid money to refer to these people. And we know they're doing it. We know the only reason they're doing it is so that broker can make money. There's no advantage to the consumer at all. And he's already told us he's coming for you guys, but yet you continue to do it. You continue to stick your head up your ass on this. And I'm afraid builders are going to do the same thing here. It's time these builders start looking at these contracts and realizing that the next Michael Ketchmark's out there who's going to bring a class action lawsuit over these unconscionable contracts. And their class is huge. It's everybody you sold a house to for the last 3 years, thousands and thousands of people. So continue to stick your head up your ass and ignore these is the lesson that we're going to see here. What builders are going to make the changes, what lenders and which agents are going to make changes, and recognize that my enemy's coming after me, and what these builders and agents are going to say, okay, it's time to make these changes because I don't want to get sued. All right. That's our show for the day. Thank you for listening to Dish and Dirt. I hope you all come back again next week for another episode of Dish and Dirt. Don't forget signing up for Realtor Mania coming up in September. You absolutely don't want to miss a live episode of Dish and Dirt. Y'all take care. Have a great weekend. We'll see you again next week.